compatibility with the Charter of Human Rights and Responsibilities Act 2006. In accordance with Section 28, I make the statement of compatibility with respect to the Rape Trial Reform Bill of 2018. I move that the bill now be read a second time. There is a disease that is inflicting our state. It festers at the very core of our justice system. It has left hundreds upon thousands of Victorians sidelined, unheard, and abandoned in our court of law. It is a shocking act of negligence that can no longer stand. Rape conviction rates within Victoria stand only at 3%. 3%. This terrifying number tells us that how our system stands today is not enough. According to the Australian Institute of Criminology, an estimated 70% of sexual assault incidents are not reported to Victorian police. Out of the mere 30% of sexual assault cases that are brought forward in Victoria, only 23% of them successfully get to court. And of those 23%, 3% result in conviction. That's 3% of 23% of 30%. This cannot stand any longer. Through the reform of rape trial processes, we would see that change. By revealing related prior convictions and offences such as stalking or sexual assault, this bill would assist in raising conviction rates to a standard more acceptable to our society. By establishing counsellors and support of third parties, as well as more concrete boundaries for the cross-examination processes, this bill would provide for and care for alleged victims of rape within the courtroom and would help to minimise secondary victimisation, as is our court system's responsibility. There is a fundamental need to care for and to provide for alleged rape victims who have been persistently disenfranchised by a system of crime and punishment that is meant to be just. A few weeks ago, the tragic rape and murder of Eurydice Dixon within Melbourne's inner north shocked our state to its core. And not 4 days later, another member of our community was sexually assaulted only 2 kilometres away from that same place. Our current rates of rape conviction send the message that those who would commit rape have nothing to fear from our courts. But we refuse to let that be the Victorian way. We uphold innocence until proven guilty, as per the very fundamentals of our justice system. But we also condone providing proper support to alleged victims of rape. The current cross-examination tactics may certainly give fair and equal treatment to the letter of the law. However, the practical implementation of such principles actually undermine the rights and dignities of the victims themselves. Due to the way that our society stigmatizes and indeed blames victims of sexual assault, as well as the effective failure of our legal system to protect these alleged victims, it is seen as easier to say nothing about sexual assault than to